Welcome back, viewers. We've been talking about transport accidents, and in particular the judgment, the Court of Appeal judgment of Gu in September 2011, Tony. Now, Tony, as we were just talking about before the break, the jury found no negligence.
Yeah, look, this was an interesting case. It was based on some directions made by the trial judge. Don, do you want to tell us what happened there?
Well, there was a couple of heads of appeals. One of them was that no reasonable jury could find such a verdict.
Which is a standard.
Which is standard.
Yep.
And for the Court of Appeal to overturn the verdict, it must find that the verdict was irrational.
Yep.
So, and also, there was other heads of appeal which included the direction of the judge. And there was a final one which appears to not have been raised so much during the trial, but at the end was where the plaintiff was charged and paid a fine for crossing an infringement notice. Well, infringement notice.
What would that have been? Jaywalking?
Yes.
Yeah, that's right.
Okay.
So the first thing was the Court of Appeal had to find whether or not no reasonable jury could have reached that verdict.
And the leading judgment by Justice Sifris.
Sifris, that's right. And they said that no jury could have found that verdict, and in fact the verdict was irrational.
So what they've done is they've found for the plaintiff.
That's right.
Overturned the earlier decision.
Yep.
And now sent it back for retrial.
That's right, sent it back for retrial.
Well, the judge has said that the jury has failed to perform its duties and sent it back for a retrial.
When you've got a plaintiff that's crossing a road, right, and he's even given evidence to the effect that the lights changed and he's tried to beat the traffic, is that a fair decision that he gets another crack at it?
Well, Tony, a driver has to have proper and due care to those that he affects, in particular, in this instance, the pedestrian in front of him. Now, the evidence was that the driver has started the car and has seen him by a distance of 1.5 metres or something like that.
He actually says never seen him.
Never sees him.
That's right.
And the pedestrian
the court
sees
found
him.
that very important.
That's right. He didn't give any adequate explanation because there was no... He had the wipers on.
Exactly.
There's no other vehicles beside him that would have hindered his view.
And he was on the left-hand side.
He was on the left-hand side. The plaintiff had crossed nearly the full length of the road.
And the plaintiff had seen him as he was driving towards him.
John,
that's right.
The fact that he gave no explanation as to why he never saw the plaintiff worked heavily against him in a Court of Appeal.
That's
right.
Correct? Well, the court found in the end that he wasn't exercising reasonable care or keeping proper lookout.
And I guess this goes back to my, what I keep saying, that, you know, these cars are dangerous weapons. The drivers must take reasonable care.
That's right.
That's entirely right.
But one issue I have with this case...
Take us to that infringement notice that he was issued by... Who gave him the notice?
By the police. The police gave him a notice.
Yep. Under what, the Infringements Act?
Yeah, under the Infringements Act.
Now, there's a section in the Infringements Act, Tony, that says that this notice cannot be used in court to say basically that this person is guilty of that act.
So it's not an admission of guilt in any sort of proceeding.
What about the Summary Offences Act? Would that be any different?
I think it'll be different. That act only deals with infringement notices.
Okay.
So this was an infringement notice for failing to obey a traffic signal.
It's not an admission of liability. However,
it goes to the issue of contributory negligence.
Exactly.
And not negligence.
That's
exactly
right. Well, at the trial, a lot of emphasis, it appeared a lot of emphasis was put by the jury on this infringement notice because he paid the infringement notice.
Oh, so in effect he's saying it was my fault.
Tony, the foreman twice during the judge's charge to the jury interrupted the judge and asked him about this infringement notice.
And what was he told?
And he was explained about it, but clearly, and the Court of Appeal has said, look, clearly it was an issue. There should have been more direction on this issue.
Okay.
The explanation wasn't, I believe, wasn't given to the jury about this. I don't even think it was raised by any of the parties.
It almost feels like we're splitting hairs because, you know, the Court of Appeal's looking at the wording that was used. And there's a lot of semantics going on here too.
Well, one of the other issues that the Court of Appeal found that the judge needed to make it clear to the jury that the accident was a cause of the driver's
and it didn't have to be
actions,
not
the cause.
Okay.
Now, it is splitting hairs, isn't it? A cause, the cause.
Yeah.
But to the normal lay person, that could be enough, Tony, couldn't it?
Can I ask you this? Let's say the notice was issued under the Summary Offences Act. Is that something that would shoot the plaintiff down completely?
Oh, look, not necessarily, I wouldn't think, just because there are different burdens of proof under these criminal acts and also the Civil Act. I mean, the Criminal Act is beyond reasonable doubt, whereas the Civil is on a balance of probability.
Because the Transport Action Commission do try and use any notices that you pay against you.
Exactly.
You know, you've had cases where, you know, 2 cars are in an accident, one gets issued with a penalty notice, careless driving or
what I would be doing is I'll be trying to raise this section, it's actually Section 33 of the Infringements Act, to try and protect myself, Tony, in that regard.
But that's the Infringements Act. What about the fact that I'm talking about the Summary Offences Act? Let's say there was 2 cars as opposed to a pedestrian here. That raises an interesting point.
Well, a lot of the evidence that would no doubt be raised in the criminal proceedings can work for or against in the civil proceedings.
So what do you think's going to happen in this case?
Look, I think obviously it's been remitted back to the county court.
Well, that's the other issue I had. The Court of Appeal judge has found that the judgment of the jury was irrational.
That's right.
Wouldn't it be easier for the Court of Appeal to basically substitute their own decision, Tony?
No, what they said was that the overwhelming evidence was against the decision they came...
Of the jury, yes.
Yeah, they came to.
And now they've just asked for a retrial again. Well, this whole thing could go on for another couple of years, Tony.
Yeah, it's possible. There's a very real prospect of that. So,
but the Court of Appeal findings did help the plaintiff. And we should state that this case, I mean, obviously there is a duty on the pedestrian to look after their own safety.
Always.
In this one, where the driver had the opportunity to see the actual pedestrian crossing, he obviously didn't and didn't provide any reasons.
And discharge reasonable care.
That's right.
All right, what do you think's going to happen at the retrial? Is there going to be... Sorry, rehearing. What's going to happen there?
Well...
How much is he going to lose? Obviously, the plaintiff's going to win his case. That's the impression I get.
Yes. There could be 10% contributory negligence, Tony.
All?
Well,
how much do you think?
Look, I think it'll probably a little bit higher. I mean, looking at the circumstance, it was dark. He was wearing dark clothing as well. Raining. Look, it could even be up to 50%. I would have thought.
I would have thought 70-30, 80-20.
Yeah.
70-30 might be.
You guys are pretty harsh.
Well, at the end of the day, I mean, the plaintiff should have looked after his own safety as well.
I think he was. It's a very long road. I mean, he hasn't walked when it was totally red. It was flashing red.
John, I don't want to get our friends at the Transport Action Commission offside.
No, I understand.
Can I just say this? Please, pedestrians, look out for your own well-being. You can't rely on other people to look after you, especially when it's dark, raining, dark clothing. It's just absolutely insane to do what this fellow did, but it also doesn't exonerate the drivers. But the clear message is look after your own safety and don't rely on other people to do it for you. But look, we're going to have to come back and bring you back another time, Don. So thanks for coming on board again tonight. And viewers, don't go away, stay tuned. We're coming back to Caffey's Mailbag after the sponsors break. Thank you.